everyone. Welcome to Crime in Court. This is the 1996 Menendez brothers retrial in the case of California versus Erik and Lyle Menendez on trial for the homicides of their parents, Kitty and Jose. This is, like I said, the retrial. First trial took place in 1993. It ended in hung juries for both defendants. They had separate juries this time around, one jury. There are multitudes of differences in this case and rulings that the judge had differently, or that he ruled differently in the second trial, and we are comparing and contrasting the two trials. So here we are. Let me get us started. As you can see on the screen, we have Judge Weisberg. Basically, the key players. We have pictures of the judge because I'm doing all the reading and I want you to have visuals of everybody. So you've got the judge, and you've got for the state, David Kahn, Carol Nahara. For Lyle Menendez, he has Charles Gessler and Terry Towery representing him. And then finally for Erik, we have Barry Levin and Leslie Abramson. Leslie is the only returning attorney. The judge, like I said, is the same judge, and he ruled differently in a lot of pretrial rulings and things in this case, and what evidence he's allowing in and not allowing in. So let's get started here. We came so the in part B. So we are, like I said, this is Jamie Pisarcik, the ex-girlfriend of Lyle Menendez, who is still on the stand. We're in the middle of her cross, and she uh, basically has some things to say about regarding whether Lyle may have asked her to lie about some things for her or for him in his trial and researching cases and whatnot. So, but she's not very credible. Well, I wouldn't say she's not credible, but she has a lot of inconsistencies in her answers. So let's continue where we left off. We're still on cross examination. Ms. Towery is doing the cross, and we left. There was a little break in between, and then we're coming right back from a break. So the court says, all right, the court is in session. If you hadn't noticed, he's referring this to Ms. Abramson. She says, sorry, Your Honor. He says, when the bailiff says that the court is in session, it is in session. Something you want to talk about before we resume. Ms. Nahara says, there is something I want to talk about before I start my redirect. The court says, yes. At this point, Your Honor, given the nature of the cross-examination, the court says the answer is no. Ms. Nahara says, to ask to see the video? Court says the answer is no. Ms. Nahara says, can we have a basis for the record? Is there some way we can? The court says the answer is no. I don't think that the examination has changed the court's view of the matter. The tape itself is irrelevant. Ms. Nahara says, I believe that the problem is that now counsel has opened the door on what was actually shown in that movie, and now there is some question. So they want to show if you forgot, the movie, oh gosh, now I can't remember what it is. At base something. Okay, so there's a movie with Sean Penn, and in that movie, the father, apparently there's a scene where the father drugs the girl and it's intended that he does something to her, like removing her clothes. Well, she's saying that Lyle told her, or there was a letter somewhere that Lyle said, something like what is in that movie. Tell them that my father said that or did that to you. But he didn't specify what scene, and she just like is saying she knows this is the scene that they're talking about, and the prosecution is saying this is the scene that they're talking about, but how do we even know? Because it wasn't referenced in the letter from Lyle, so it's all kinds of sort of confusing. But now they want to bring in that scene of the movie to show the jury when there's, again, no reference from Lyle about that particular scene specifically. So it's not It's not accurate. It would be portraying an incomplete picture, perhaps, to the jury. I'm not sure what that legal standing is, but you know what I mean. It's not the clear picture. So Ms. Nahara says, I believe that the problem is now counsel opened the door and they want to play the movie. The court says, I think it was opened by you showing the witness the movie. That's what happened. You showed the movie and you showed it to her with the idea that you were going to be able to play the tape for the jury. And the answer is no. Let's bring the jury out. Finally, like he's kind of snippy. He's not in a good mood today, apparently. Um, but finally, he's snippy with the prosecution because usually he's more so snippy with Ms. Abramson. Ms. Towery says, Your Honor, before the jury comes out, would the court consider admonishing the jury at the close of today's session to not to go out and watch the movie, just on the off chance that they might be inclined to do so? The court says, Sure. Ms. Towery says, Thank you. The jury enters the courtroom. The court says, All right, the jury is back. You may continue your cross examination. And as a reminder, this testimony is only to be considered for Lyle Menendez, not Erik, because this is a witness that only had conversations with Lyle about what she's testifying to. So, all right, the court it says we're back. Cross examination begins. Thank you, Your Honor. Um, Now, you mentioned in your direct examination that between the time that you broke up with Lyle Menendez and the spring of 1989 and August of 1989, you used a calling card that Lyle told you was his calling card. Is that right? Yes. And you said that you thought it was a Watts line. Is that right? That's how he described it to me. When he gave it to you to use, he described it as a Watts line? Well, it was really before calling cards had come out, at least before I had any experience with calling cards, and he described it as just kind of being a number that he had access to and that to use that I could use. And what's a Watts line? I believe a Watts line is where it's paid for, I guess maybe monthly or something like that. By whom? I don't know. You don't know what a Watts line is. Well, I believe that that's what it is, but I am not sure. And you weren't sure at the time that he gave you this calling card to use. Is that right? Yeah. When did he give it to you? I would imagine probably sometime when I was living in Birmingham, Alabama. During 1987? I really don't recall. And you also said that Lyle Menendez said that it was a line for you and your sister and others to use just on a casual basis. Is that right? Yes. For those of you who are young and don't know what a calling card is, calls, we didn't have cell phones, and long distance calls, like even to the town over, could sometimes be considered long distance calls. So you would get charged like massive amounts of money for long distance calls. They really like screwed people over by doing that. Eventually, like they got rid of that, and you can call anybody in the world on your cell phone, and it's not considered necessarily a long distance call. But back then, that's what it was. And you had to use a calling card, or you didn't have to. You could use these calling cards. You would like call in a number first before you would call the number, and then that would take payment from that prepaid calling card, or if you pay it like on a monthly basis, I guess it would add up and tally up your totals. So that's kind of an explanation of that for you young folks, if there's any people out there that didn't understand. All right, so she says she doesn't recall what year he gave it to her. And you also said that Lyle Menendez said that it was a line for you and your sister and others to use just on a casual basis. Is that right? Yes. How many sisters do you have? I have two. And you were present when Lyle Menendez gave this Watts line number to your sisters. Well, I was in Birmingham, Alabama, and I remember my sister sitting there, and I believe that's the time that Lyle gave it to my one sister. All right. So you were present when Lyle Menendez gave this Watts line number to one of your sisters. Is that right? Well, I think it was about that same time. I don't physically remember Lyle saying it to my sister. I don't remember that exact time, place, that sort of thing. What about your other sister? Were you present when he gave her the Watts line? No. But you somehow know that he did that. Well, he obviously had contact with my sisters even after I broke up with him. So you are assuming that he gave it to your sisters as well as yourself and said that you could use it just on a casual basis. Is that right? And that's what my sisters told me. And did he also give you permission to use it after you broke up with him in April or so of 1989? Well, no. That topic was never discussed. So he had given it to you and perhaps your sisters when you lived in Birmingham, Alabama, and said that you could use it on a casual basis. Is that right? Yeah, I think so. Now, when the prosecution originally contacted you in this case, Ms. Pisarcik and Detective Zoller came to your door in October of 1992. Is that right? October 92, did you say? 1992. Okay. They showed up at your house and talked to you. Is that correct? Right, yes. And they told you that the reason they were contacting you is that they wanted to ask you about a phone call you had made using the Menendez family credit card on the same day as Lyle's parents, or the same day that Lyle's parents' lives were taken. Is that right? I believe so. Yes. And they asked you whether you used the card to call your friend Kelly in Pennsylvania. Is that right? I believe that's what they asked. Correct. And you told them that you had permission to use the card, but you did not think that you made the phone call because at the time of the homicides, you weren't seeing Lyle. Is that right? Are you asking me if that's what I stated? Is that what you stated? I believe so. And then a month after you gave your taped statement under oath in November of 92, correct? Mm-hmm. And at that time, you said that you had thought about their question about your use of that phone card after they had come to your house. Isn't that right? Yeah. So she's changing her testimony or her statements. And at that time, you told them that Mrs. Menendez had given you permission to use the card to arrange for Lyle to play in a tournament in Vermont that weekend. That is the weekend of the homicides. Is that correct? Yes. And you told them that you had sent Mrs. Menendez an entry blank for the tournament and she gave your permission to use the card to call and make plans and all that kind of stuff regarding the tournament. Is that correct? Mm-hmm. Yes. And you didn't mention anything about Lyle Menendez giving you a Watts line along with your sisters to use on a casual basis. Is that right? Well, I think I tried to explain that it was. He had given this number to me and that it was kind of lightly used. You know what I mean. I thought I tried to explain that. You tried to explain that at the time they talked to you in November of 1992. Well, it's what I tried to explain. Today, when I was questioned, yes. And yesterday, when you were asked about it, is that right? Yes, yes, yes. Emphatically, yes. But at that time, you told them that Mrs. Menendez had given you permission to use the card to arrange for Lyle to play in a tournament in Vermont that weekend. Isn't that correct? So, not that Lyle gave you the card, but that it was given to you that weekend of the homicides, which I think she had the card prior to that. She says, "Well, yes. On that one incident, she did. So I guess on that one time she gave her permission to use the card." So she gave you specific permission to use that card to arrange for a tournament. Is that correct? Well, it was kind of like, Jamie, you've got the card number, right? And I was like, yeah, it was very casual. And you obviously stayed in touch with Mrs. Menendez after you and Lyle broke up. Is that right? Not really all that much, but just as we were trying to arrange for his tournament. Okay. That was pretty much your only contact with her after you broke up with Lyle in April of 1989. Is that correct? I would think so, probably. Did you call her or did she call you? I don't recall. I mean, Lyle and I first started talking about the tournament during earlier in the summer. We were planning to make plans for it, and I don't recall if I called her and told her I would get the entry. I don't remember. You were living back in the Princeton area at that time in Lawrenceville. Is that correct? In Lawrenceville, correct. Yes. Did you use the card to call Mrs. Menendez? I don't remember. Was Mrs. Menendez trying to get the two of you back together when you were when you were talking to her about arranging for Lyle to go play in a tennis tournament back in Vermont? Ms. Harris says objection, calls for speculation. The court says overruled. You may answer the question. The witness says, I don't really know what her intentions were other than trying to get Lyle entered into the tennis tournament. She didn't say anything about trying to get the two of you back together. I don't think that was a topic of conversation at that time, no. So at some time she must have said something, but maybe not at that time. Now, you sent her an entry blank for the tournament. Is that correct? Objection, irrelevant, overruled. I think that's what I did, was as far as I got the entry blanks and forwarded one, or maybe she wanted me to fill one out for Lyle. I don't remember. You said in 1992, when you gave your statement under oath, that you sent her an entry blank for the tournament. Is that right? That must have been accurate then, yes. And you also said that you were to use the card to make plans and all that kind of stuff regarding the tournament. Is that right? Mm-hmm. Yes? That's what we were trying to do. And did you talk to Lyle about whether he was going to the tournament? Objection, irrelevant, overruled. Well, yes, of course. Did he say he was going to come? I was assuming that he was going to be there, yes. Did he say he was going to come? At some point he did, or I would not have been obviously trying to get him there. Your answer is yes, he said he was going to come. He was trying to go, yes. Is your answer yes? Yes. Like, how hard is that? Just answer the question. Did you testify at the last trial that it was not definite that he would show up? Well, as I just stated, he was going to try to come. So, did you testify at the last trial that it was not definite that he was going to show up? I don't recall. I think it's stating the same thing, what I just said. Ms. Towery says, page 22, 321, may I approach, Your Honor? He says, yes. Ms. Towery says, thank you. Let me just show you a transcript of your testimony at the previous trial and ask you to read the line at the bottom of page 22, 321, and the following two lines on the next page. Okay, what number? The bottom line. Okay, okay. Does that refresh your recollection as to whether or not you said that it was not definite that he would show up? It said that, and I think does that refresh your recollection? Yes. Did you say that? Yes. Did you call him you went to the tournament, I assume, is that right? Yes, I did. And when did that tournament take place? It was, Ms. Nair says, I'm going to object under 352, overruled. It was a weekend tournament. I believe I got there Friday, and it was probably Friday, Saturday, and Sunday over the weekend. And you left on Sunday? I believe I did. And that would have been August 20th, 1989, correct? That's the day of the incident when Jose and Kitty's lives were taken. She says, correct. Did you ever call him to find out why he didn't show up at the tournament? I was busy playing. Is your answer no? Yeah, no. You did not call him? No, I did not. And did you ever call Mrs. Menendez to find out why he didn't show up at the tournament? No, I did not. Why wouldn't you? What exactly were you going to do to arrange for Lyle Menendez to play in this tournament? Objection, irrelevant, overruled. Well, entry blanks, that type of thing. You sent the entry form to Mrs. Menendez, didn't you? Correct. So she was going to do that, isn't that right? I would assume so, yes. What else were you going to arrange? Were you going to arrange his flight? No, not the flight, but probably housing up there. There was a lot of different things that go into playing in a tennis tournament. Did you arrange his housing? I don't recall. I do recall talking to Ted Macbeth, who was a tournament director, and finding out information about the men's tournament. Did you arrange Lyle Menendez's housing? I don't recall. Do you know where he was going to be staying if he went to the tournament? They had separate housing. We housed with different families. So, no, I don't know exactly. You don't know where he was going to stay if he went to the tournament? No. Now, your friend Kelly, who was called on August 20th, you did call your friend Kelly on August 20th, didn't you? Mm-hmm. Was Kelly helping to arrange the tournament for Lyle? Kelly was actually Eric's girlfriend, but she was in the tennis tournament. Was she Eric's girlfriend at the time? Ms. Nahara says, I'm going to object, no personal knowledge. Sustained. Ms. Towry says, do you know whether Kelly was Eric's girlfriend at the time on October 20th? I don't remember. I don't think so. I don't know. But she was your friend, correct? Yeah. And when you called Kelly, did you call her in Pennsylvania? Objection, irrelevant, overruled. Oh, I'm sorry. Miss Towery says, did you call Kelly in Pennsylvania when you used the card to call her? I don't know. That was what the prosecution came to ask you about in October of 1992 about your calling your friend Kelly in Pennsylvania with the calling card. Is that right? Correct. And the tournament was in Vermont, right? Right. And the tournament was over, wasn't it? It was. Now, when you testified at the trial, Lyle Menendez's former attorney, Ms. Lansing, showed you phone records. Mm-hmm. Of many, many calls that you and your family made using the phone card after the breakup with Lyle Menendez in April of 1989 and before August 20th. Is that correct? Yes. During that entire period, is that right? Yes. And those phone calls weren't to arrange the tournament in Vermont, were they? No. So confirmed, she confirms it, the witness confirms it. She had been her and her family had been using the card for apparently many, many calls between the time after Lyle and her broke up and the day of the homicides. And those phone calls weren't to arrange the tournament. She says no. And before Ms. Lansing showed you those records at the last trial, Ms. Lansing was Ms. Lansing was Lyle's attorney in the last trial. Before Ms. Lansing showed you those records at the last trial, you said that you didn't recall whether you used the card after you broke up with Lyle Menendez, didn't you? I must have stated that. Well, did you say that? I must have. I don't remember, but I guess so. Ms. Towery says, page 22, 323. Ms. Nahara says, that's fine. Ms. Towery says, may I approach, Your Honor? He says, yes. I will ask you to look at page 22, 323 of your prior testimony, lines 23 through 28. Okay. Do you now recall that you testified that you did not remember continuing to use the phone card after you broke up with Lyle Menendez? Yes. And then you reviewed the phone records, didn't you? Correct. And that's when you said that Lyle Menendez had given you permission to use the phone card at any time. Is that right? Yeah, like I said, it was a very casual thing, and he threw the number around to not only me, I'm sure other people too. And you said that he gave you permission to do that a year earlier. Is that right? I wasn't definite, but I think it was sometime when I was in Birmingham. Did you testify at the last trial that Lyle had given you permission to use the phone card a year prior? That would have been while I was in Birmingham, yes. So you were in Birmingham in 1989. Well, actually 1987, all of 87. So you were using the phone card during April to August of 1990. Is that correct? Objection, irrelevant. Overruled. Can you repeat those dates? You were using the phone card between April of 1989 and August of 1989. Is that right? I believe those phone records showed that I used it a few times. And you testified that Lyle had given you permission a year prior. Is that correct? Mm-hmm. Mm-hmm. Objection asked and answered. Overruled. You also testified that after you were shown the phone records, you also testified that you may have used it during the breakup if you talked to him sometimes that summer. Is that right? Yes, possibly. You also testified that he gave that card to both you and your sisters to say, if you want to call your mom, my mom. Did you testify to that effect? Ms. Nahara says, I'm going to object to anything she testified to as hearsay without a proper foundation. The court says, sustained to the question. Ms. Towery says, your testimony regarding the phone call yesterday was that you were permitted to use the phone card, as were your sisters on a casual basis. Is that right? Correct. Ms. Nahara said I would object as to any question as to the testimony without proper foundation. The court says, overruled, the answer will stand. Ms. Towery continues. And there were phone calls in the records that were shown to you at the previous trial from your sisters to their friends. Is that right? Objection, irrelevant what her sisters did. Overruled. I really don't know who they called. I don't know if they were friends. I don't know. You saw records of phone calls to people who were friends of your sisters. Is that right? Whose names you recognized? Yeah, I think I recognized the cities, not necessarily the names. Did you recognize the name of Ike Gross or Gross? Yes, I did. And that's a friend of your sister's, correct? Objection, Your Honor. Overruled. Mm-hmm. Yes? Yes. And there were phone calls made to that person, correct? Yes. And there were also phone calls in the records from all of you and your sisters to your father, correct? I believe so. I object to anything in the records as hearsay. Overruled. I believe so, yes. And there were also phone calls in the records that you reviewed from you and your sisters to your mother. Is that right? Mm-hmm. And there were phone calls from you or your sisters to your mother's home in Pittsburgh. Is that right? I believe so. And there were also phone calls to your mother's place of business. Is that right? I I am going to object vague as to time, says Miss Nahara, sustained. Ms. Nahara says during the time frame that I'm talking about is the time frame between April of 1989 when you broke up with Lyle Menendez and August 20th of 1989. Do you understand that? Yes. And there were phone calls to your mother's place of business during that time. Is that correct? I think so, yes. And where does your mother work? Ms. Nahara says I'm going to object as irrelevant, doesn't tie into the witness. Sustained. There were also phone calls, quite a number of phone calls, to a man named Richard Garrett. Is that right? Yes. I'm going to object as irrelevant as to no foundation as to this witness. This Ms. Nahara does not want this all to come in. She's objecting to everything. The court says overruled. And the witness says yes. Ms. Towery says, and when you testified at the previous trial about these phone calls or phone records, you said you didn't recognize that name, didn't you? Well, on the phone records it said Richard Garrett, and he didn't go by Richard. You said that you didn't recognize the name Richard Garrett. Is that right? Not as Richard Garrett, no. And you had to be reminded that Richard Garrett was your roommate at Mercer College, didn't you? He wasn't my roommate at Mercer College, no. He was not your roommate at Mercer College? No, he wasn't. He was my roommate. I rented a room for him in Lawrenceville. He didn't go to college. Okay, you're just parsing words now. Reading from the transcript at page 22, 329, Your Honor, lines 11 through 21. May I? Question. We have a call to someone named Richard Garrett. Who is Richard Garrett? Richard Garrett was from Birmingham. Who is Richard Garrett? I don't remember. I don't know. Richard Garrett was your roommate when you were attending Mercer College. Do you remember that? Rick? Yes. That Richard Garrett? Yes, he was a roommate. Was that your testimony? Well, yes, but you just asked me if he was my college roommate. I was attending some classes at Mercer. He never went to Mercer College. I am sorry, I misunderstood. I rented a room from him. I actually met him at the restaurant. He was an employee at the restaurant where I worked. And you were shown records that had as many as 11 long distance calls per day on the card that you were provided by you and your family members. Isn't that right? Ms. Harris says, Your Honor, I'm going to object to anything about the records, the contents thereof, as hearsay. You already objected. Overruled. Ms. Tory says, Is that right? I guess so. And you said that you didn't know that it was a Menendez family phone card that you were using. Is that right? Yes, I did. As I stated, Lyle said it was a Watts line of some kind. And do you think that no one pays for a Watts line? Objection. Argumentative. Overruled. I guess at the time, I really wasn't thinking about it. So she just thinks like he gives out this number and money just comes from nowhere. The calls get paid out of nowhere. Like no, it's coming from his parents who are obviously paying for these calling cards or whatever, the Watts line. Ms. Tari says, Did you think that this was something that people could just make free long distance telephone calls on? I don't know. You never offered to pay for the phone calls that you made, did you? No, I did not. And you never did pay for the calls that you made, did you? I guess I was never given a bill. No one asked you to pay for the calls? No, they did not. Now, in your testimony yesterday, you said that Lyle gave you this card for you and your sisters to use on a casual basis. Isn't that right? Mm-hmm. Yes. And you previously testified that Lyle Menendez used the card on a casual basis, didn't you? That's the only way I ever saw Lyle make a phone call was with the phone card or with that number. Always used a phone card or that phone card. Is that right? I'm assuming it was that phone card. I don't know for sure. And you used it on a casual basis. Is that correct? Yes, it is. Now, first you told the prosecutors that you didn't think you used the card. Is that right? When they first came to your house? Well, yes or no? Ms. Nahara says, Okay, I'm going to object, Your Honor. Believe the witness is trying to answer the question. The court says, Well, it could be answered with a yes or no. And that's exactly what a judge should do, not like Judge Canoni, who just lets witnesses ramble on and on in the Karen Reed case when it should be a yes or no question from the defense. The witness says, Can you please restate the question? Ms. Harris or Ms. Towery says, When the prosecutors first came to your house and asked you about the phone call to Kelly in Pennsylvania, mm-hmm, you said that you didn't think you used the card because at the time of the homicides you weren't seeing Lyle. Is that what you said? It is. And then later, a month later, you said you had thought about it and you did use the card because Mrs. Menendez had given you permission to use the card to arrange for the tournament in Vermont. Isn't that right? Correct. And then after you were confronted with phone records showing use of the card by you and your family for the entire period, as many as 11 times a day, that's when you said that Lyle Menendez said you could use that card at any time. Is that right? 11 long distance calls per day. Yes, it is. And the first time you described it as a Watts line was when you talked to the prosecutors on October 12th, 1995. Isn't that correct? I'm going to object under 352, Your Honor. Overruled. The witness says, well, I had a long time to think about it, and yeah. So you did have a long time to think about it, didn't you? Yes. So the first time you described it as a Watts line was 2 weeks ago when you talked to these prosecutors. Is that correct? Well, it was the first time that it was asked of me, and after being able to review my testimony. Weren't you asked about the phone card and the use of the phone card extensively at the last trial? Yes. And you never said anything about a Watts line, did you? No, not at that time, no. And didn't you use this card after you broke up with Lyle Menendez because you thought that the Menendez family was rich and it didn't matter? That's a good question. No. Didn't you use this card because you thought that no one would notice? I think I explained why I used the card. Is that your answer? Yes or no? Can you restate your question? Did you use this card because you thought that no one would notice? No. No one did notice that you were using the card until the police came and asked you about your phone call to Kelly, did they? I don't know. I don't know if Mr. or Mrs. Menendez knew. I really don't know. No one asked you to pay for the calls that you were making, is that right? That's correct. That's correct. Nor to pay for the calls that members of your family were making, is that right? That's correct. Now, you said here today that you and Lyle Menendez continued dating after you broke up with him in April of 1989. Is that right? I think I stated that. We saw each other. Didn't you say that you continued dating? And as well as dating other people, so it wasn't exclusive. Okay. When you testified at the previous trial, didn't you say that you and Lyle Menendez were not going together after the breakup? You were just friendly. Yeah, probably. And now you're saying that you were dating him during that summer because you used the card after you broke up with him. Is that right? Well, we saw each other. Like I said, he came to see me, so yeah, we were friendly. My question, this is infuriating. My question is, are you now saying that you continued dating Lyle Menendez after you broke your engagement with him because you continued to use that card? Isn't that right? No, it was because I had time to think about those questions that I was asked last time on the stand. It was the first time that I had ever been asked those questions. And you had time to be confronted with records showing you just how much you did use the card. Isn't that right? Objection, argumentative. Overruled. Well, if you look at those cards, I mean, I don't really know how many times I use the card. And as far as I'm concerned, it was Lyle's responsibility to tell whoever he gave that card to not use it, including you. Yes. So as far as you were concerned, you could use it until he said to stop using it. Is that right? Well, I don't really think that I used the card all that many times. To tell you the truth, it was several times. It was my mistake to use the card, obviously. And after you broke up with Lyle in April of 1989, he started dating a woman named Christy, didn't he? Objection, no foundation. Sustained. Did he tell you that he was dating a woman named Christy after you broke up with him? Objection, hearsay. Sustained. And your recollection regarding the agreement that you had with Lyle Menendez as well as your family had gotten better over the years, hasn't it? Can you restate that? Yeah, that was confusing. Your recollection as to what was discussed about the calling card between you and Lyle Menendez has improved since 1992, hasn't it? Objection, argumentative. Court says, as phrased, it is. Ms. Towery says, you said that you have gone back over your testimony and now you remember things. Is that right? Objection misstates the testimony. How? No, it doesn't. Overruled. Well, that's pretty obvious that's, when you go over testimony, you're going to remember. That's a yes? Yes. So your recollection is better now than it was in 1992 when you first started talking about your use of the card. Is that right? Well, I've had time to review it, so yes. Again, if any witness is saying that their memory is better now than it was in the past, they're lying. This is a liar. That's not how memory works. Over time, it fades and becomes worse and worse. And every time you think of a memory, you're remembering the last time of that memory. So your memory it's like playing phone tag with your own memories. And it's very, you can absolutely trick yourself with what you think you remember and what actually happened. Now, you met with the prosecutors for the first time in October of 1992. Is that right? At your house? Yes, when they came to my house. And you gave the sworn statement a month later in 1992. Is that right? Yes. And then in November of 1993, you met with Detective Zoller again and gave him another statement. Is that right? November 1993? Yes. Yeah, I guess so. And then you testified for the prosecution at the previous trial, correct? Correct. And you met with the current prosecutors on October 12th, 1995. Is that correct? Yes. And during that entire period of time, you refused to meet with the defense, didn't you? I got a letter asking if I would meet with them. No one ever contacted me, I don't think. So you received a letter asking you to meet with the defense. Well, I received a letter from Jill Lansing asking if I would meet with her, but no one answered up on my front door, or no one showed up on my front door like the prosecution did. I am sure I would have answered their questions had they. So that letter, I'm sure, said, please contact us at this phone number or whatever. We can arrange a meeting. So why didn't she follow up? Why, that letter was them contacting you. The attorney says, okay. I have a document, Your Honor, that I'd like to mark as is it 161? The court says 162. 162, thank you. May I approach, Your Honor? The court says yes. I am showing you a letter, Ms. Pisarcik, dated September 25th, 1992, and addressed to you from Ms. Jill Lansing. Mm-hmm. And that the letter that is that the letter that you're talking about? It is. And did you receive that letter? Correct? Yes, I did. And you received it. It's dated September 25th, 1992. You received it shortly thereafter. Object to any reference to the content as hearsay, particularly the date. The court says there hasn't been any representation as to the contents yet. Ms. Harris says, I believe the date is what I am talking about, Your Honor. The court says she said she received it, so overruled. You received it shortly after the date of the letter. I believe so. I don't remember when I received it. Objection, motion to strike, no foundation. Overruled. And this was the letter in which you were referring to, in which you received a request from the defense to meet with you. Is that right? Yes. And Ms. Lansing wrote you a page and a half letter indicating that she would like to meet with you regardless of your feelings about Lyle or the defense. Is that right? I would object to what Ms. Lansing wrote in the letter as hearsay. The court says sustained. Ms. Towery says, but no one ever followed up on that letter. Is that your testimony? I would object. That assumes a fact, not an evidence. I believe the previous answer was sustained. Overruled. The witness says, well, no. No one showed up on my doorstep, like I said. No one called me. Ms. Towery says, you responded to that letter, didn't you? Yes, I said that I didn't want to have anything to do with the case, as I didn't. Well, I have a document that I would ask to mark next in order 163, Your Honor. Court says 163. She says, thank you. May I approach, Your Honor? Yes. Showing you a handwritten, single-page letter dated October 11th, 1992. Do you recognize that document? Yes. Is that a document that you sent back to Ms. Lansing? Yes. Would you read it, please? Objection. Calls for hearsay. The court says, what's the date on this letter? Ms. Towery says, October 11th, 1992. The witness says, 11. What was the date of the letter, says the court, or asks the court. Ms. Towery says September 25th, 1992. The court says, all right, your objection is what? Ms. Nahara says, it's hearsay, Your Honor. The court says, all right, let me see the letter. Okay, you may read it. Ms. Towery says, would you read it, please? The witness reads the letter. Jill, I am in receipt of your letter dated September 25th, 1992. I appreciate your concern for my well being and I appreciate your understanding that I do not wish to be involved in the Menendez case. I have not been in contact with Lyle or anyone in the Menendez family for 1.5 years and do not wish to be. It is encouraging to know that that you will never put me on the witness stand against my wishes. I will not meet with anyone regarding this case voluntarily. Wow. Okay, so she really didn't want to be on the witness stand, and she said she didn't want to be meeting with anyone voluntarily. That really shows her state of mind at the time. It is of no concern to me whether this is a capital trial or any other. I do not wish to be involved. Sincerely, Jamie Pisarcik. Ms. Nari says thank you. I have no further questions, Your Honor. Pretty strong way to end your cross-examination. The court says, all right, how long is your redirect? Ms. Nahara says, I'd say about 40 minutes, Your Honor. The court says, okay. All right, we'll be in recess until tomorrow morning. Don't discuss this case with anyone. Don't look at any of the news coverage about the matter. Don't speak with anybody about it in any form whatsoever. Don't form any final opinions about the case. There has been a reference to a movie during the examination of this witness. It is very important that you do not go out and look at that movie. Don't rent it. Don't look at it. Your decision in this case is based on the evidence you see here in the courtroom and not anything else outside the courtroom. So you are not to go out and do any investigating on your own. It would be improper for you to do that. All right, we will see you back here 8:30 and the jury exits the courtroom. We have a little bit of argument here, and then we will get to the next day. Now, this is outside the presence of the jury. The court says we will be in recess until tomorrow morning. Mr. Khan says there is one thing I wanted to put on the record. The court says yes. Mr. Khan says, yes, I just wanted to advise the court of the developments in regard to the expert witnesses in this case. The court asked me to interview Dr. Lawrence and to determine whether, in fact, I believe he can lay the foundation necessary for the introduction of the testimony of Roger McCarthy. And I did have a conversation with him, and I am satisfied that he can lay the foundation, and I will discuss with counsel the various statements that he made to me concerning that issue. The other thing I wanted to put on the record is in regards to the manner in the manner in which we are going to be presenting this evidence. Initially, we had indicated that we would prefer to do it through Mr. McCarthy, Dr. McCarthy. No, isn't it Dr. McCarthy? No, Mr. McCarthy's uh, testimony. Computer. Wait, what? We had indicated that we would prefer to go through Mr. McCarthy's computer. As I suspected, I don't think Mr. McCarthy particularly wants to leave his computer. Ms. Abramson says he doesn't have to. We don't need his computer. Mr. Khan says we will nevertheless present the evidence through physical exhibits, through photographs and illustrations, rather than using the computer itself. Ms. Abramson says, well, I need to see then what it is, how they're going to do it. Mr. Khan says, it is the same thing we have already gone over. We just have hard copies of it now instead of doing it through the computer. The bailiff says, are you ready, Judge? The court says yes. The jurors walk through. Ms. Abramson now, so they must have to walk again through the court to get they must go get their things out of the jury room and then have to walk out of the court or something. So they have to pause proceedings. Now they're gone. Ms. Abramson says, Your Honor, rather than have counsel make statements to me over which, as we know, people can differ, I would like him to just write down what it is by way of discovery Dr. Lawrence is going to say that counsel believes supports Dr. McCarthy's theories. I don't want to get into a spitting contest about how things were phrased or what Mr. Khan said, and it would be useless for me to use anything with Dr. Lawrence. For example, if Dr. Lawrence testifies to what Mr. Khan says versus what he told me, I need, or to what he told me versus what he told Mr. Khan, I still think it's best if Mr. Khan gives me notes in writing. I am not doing that in order to delay the receipt of discovery. I just don't find it's as useful in verbal form, unless he wants to recite it on the record so there is a writing I can use. The court says, I don't care how you do it. If you want to put it in writing, that's fine, or you can each sit there with your own tape recorder and tape record it and have a third tape recorder for good measure. But I don't think you need to put it on the record. Ms. Abramson says, I just want to put something in writing. Mr. Khan says, I will put it in writing. Ms. Abramson says, good, and tomorrow sometime we should talk about the photographs the people intend to use with Dr. Lawrence. Mr. McCarthy, I know which ones I think Dr. McCarthy was using, but I don't know what they're going to show Dr. Lawrence. The court says, first talk amongst yourselves and get what it is, and we won't have to discuss it any further. Ms. Nahara says, there was another witness, Martin Howell. These are all new names, by the way. I don't recognize them from the first trial, and I don't recall the state having any real major key witnesses to. They definitely didn't have anything to combat the abuse, but I don't know. They didn't have all these other doctors that I am aware of. Or these names are not familiar to me. Ms. Nahara says, for some reason, I want to call him Martin Howell. Ms. Abrams says, we have some written notes that form the basis of the stipulation. Ms. Nahara says, as to Miss Sugarman, Ms. McHugh, and Miss Howell, Mr. Howell, the court knows and can take them off the witness list. There are going to be stipulations. The court says, okay, we'll see you back here tomorrow at 8:30. We are now moving on. If you're following along, there is a link to the documents below, all the different testimony and transcripts, all the resentencing hearing court documents. Everything is just in the description below. You can find the transcripts and follow along, or even sneak peek ahead a little bit if you wanted to, for the trial. For the transcripts. This is November 2nd. We are moving along to November 2nd, 1995. Sorry, 95. We're in 95. The trial concludes in 96. The court said, so we're back on the record for November 2nd. No jury present at the moment. The court says yes. Ms. Abramson says, I just wanted the court to know that I was given notes written by Mr. Khan of Dr. Lawrence's position supposedly supporting failure analysis. I just want to submit this to the court, so if this comports with what the court had indicated, it would have to show in order to support his testimony. The court says, no, I have never indicated any particular thing that would have to be shown. You were the ones alleging, in speaking with him, that his opinions don't conform with Mr. McCarthy's or with Dr. McCarthy's testimony. I have no way of evaluating that. Ms. Abramson says, I'll have another chat with Mr. Lawrence unless he no longer wishes to speak to us. The other thing the people have told us verbally, orally, I guess is the right word, that they have, quote, new information from Brian Anderson, who's a witness scheduled, I believe, for today. My understanding was Brian Anderson was only being called in this part of the case to establish one fact concerning a camcorder. Brian Anderson is the brother of Kitty Menendez, one of the brothers of Kitty Menendez, and both multiple brothers of Kitty Menendez opposed the brothers' resentencing. They basically wanted them to get the death penalty. They sued them after the first trial. You know, just not uncle type things that you would do. They were, I mean, understandably upset about what happened to their sister. However, those boys, they were boys at the time, or, young men, boys, not quite fully developed brains still. Um, they were They're flesh and blood as well, and they should have been more kind and compassionate and understanding to the brother's situation and what was going on in that household. But they didn't want to see it. And sometimes that happens with victims. We see that in the Karen Reed case where the victims of uh or the family members of Officer O'Keefe have like a blinding, searing hatred for Karen Reed. Same with like Idaho 4. You hear Steve Gonzalez constantly talking about how much he hates Brian Koberger. And Brian Koberger hasn't been convicted yet. So we know, like it happens often where you get a blinding, searing rage and you're so blind with hatred for what happened to your loved one that you don't see the evidence that's clear and right in front of your face. But I digress. Let's move on. She says, my understanding, right? Who's talking? Ms. Abramson. She says, my understanding was Brian Anderson was only being called in this part of the case to establish one fact concerning a camcorder and a conversation he had with Mr. Menendez about Mr. Menendez going to talk to Lyle about it and that it was admissible only against Lyle Menendez. Therefore, I didn't even bother trying to prepare for that witness. And now we're being told about a statement. The court says, wait, wait. The jury enters the jury room. The court says, okay, go ahead. Ms. Abramson says, yes, Your Honor. Now the people, I don't know if the people intend to use this in this part of the case. I assume so, or they wouldn't be telling me about it. Now they want to introduce information from Mr. Anderson concerning conversations he had with both defendants right after the homicides here in California concerning the will and whether they're in it or not. Apparently, his statement, although I haven't seen it in writing yet, is that they told him they knew they were in the will, etc., etc., and so forth. And just flipping through my notebook on him, as I say, I had not prepared to deal with this witness because he was not being used against us. Let's see. He had a police interview on September 14th, 1989. He had an interview with Ms. Bazanich and Mr. Kuriyama on November 21st and November 22nd, 1993. He had an interview on February 22nd and February 23rd of 1994 with the prosecution, and this has never come up before, and we feel this is way too late for discovery of this kind. I am certainly not prepared to. I still haven't seen it in writing. I'm waiting for Detective Zoller's notes, and I'm certainly not prepared to deal with this kind of issue from this witness. As the court is well aware, there were numerous family members who were here in California after the homicides and before Mr. Anderson should be permitted to testify to any events during that week, which he has never given information about before. We would want to interview all of those witnesses and go through all of our records of our clients' whereabouts and those witnesses' whereabouts during that period of time, etc. So I haven't even seen the discovery yet. It's kind of weird to object to something you haven't seen. I take Mr. Khan's word for it that it is of the character that he has represented. The court says, okay, Mr. Khan. Yes, we do intend to introduce this. This is something he just told us for the first time last night. Really? Something that he recalled. It's not correct to say the only reason he's being called is in regard to the camcorder. We have now learned he was present during two other significant activities. One was the search for the safe at the home of the attorney, Randy Wright, and the other was for the search of the will, all the safety deposit or of the will at the safety deposit box. We'll be asking him about the search for the will as well as the camcorder incident, and we propose to ask him about the conversation with the defendants as well. Ms. Abramson says, well, Your Honor, this is a first since the first we've heard they're offering him for those purposes. I mean, we have all those proffers. We've litigated all these witnesses. We've line by line what we've gone line by line what they said, and this is the first we've heard. And they've known all along that we were here at the time and we had something to do with the safe deposit box and the will, and they've never been proffered that before. And we don't know what statements he's going now to try to attribute to our clients during those activities. So we would object to anything beyond what was litigated, or anything beyond what we litigated was going to be the scope of his testimony at this stage of the case. The court says, well, certainly litigation had to do with out of court statements of one defendant and how it would be dealt with in the joint trial. It was never the focus of other testimony of the witness, one way or the other, as to what he would or would not be permitted to say. You are a jackass, Judge. But okay. Whoops, I didn't mean to underline. Whatever. It was clear to me, quite frankly, from how the examination was conducted of the rights and Mr. Baralt, I assumed that Mr. Anderson was going to be called to testify about the incident at the Wrights house. At the very least, so he's saying it's going to come in, the whole whatever, this this examination. At the very least, just from the way the examination was conducted. So from my perspective, and I know less about the discussions that you have with the lawyers. I don't know anything about them, and I don't know anything about the discovery that's been turned over. I just assumed that was going to happen. Ms. Abramson says, we did not, and none of us are prepared to deal with that at this point in time, at least not at this point. And I don't know, and I want a 402 with that witness, whether he's going to testify to any statements made by either of the defendants. The court says, I think you're entitled to discovery of any statements made by either defendant at any time pertinent to this witness. Ms. Abramson says, with respect to this new statement where they're discussing the will, Your Honor, we would object to that coming in at all at this point because this is the first time we've heard of it. We don't know any of the specifics or details at this point. The court says, well, first of all, let's have a written report of what it is that the witness will say before we get further along. I think you're entitled to that. And it's unclear to me how it came about that this witness disclosed that today or last night versus some earlier occasion, whether he had ever been asked about this before. As far as inheritance, the defendant's state of mind in regard to inheritance, one would think that he had been, and what his responses were before and how it came about that he discovered or disclosed today or yesterday or last night, whatever it is. I think these things are all things that you're entitled to before he testifies. Is there a report being prepared in this regard? Mr. Khan says, not a report, but Detective Zoller will be bringing his notes with him this morning, and we will have copies of his notes for counsel. The court says, and do these notes reflect any statements that were made by the defendants during the time? I think there already are some reports showing some statements by the defendants at the time that the safe was searched, as I recall. The notes that were shown to the court related to the hearing involving Mr. Wright, not Mr. Anderson. The court says, Detective Zoller testified. I don't know if I saw the notes or in his testimony that it was also in his report because I saw his report as part of the offer of proof that we spoke with Mr. Anderson about that situation, and there were certain statements I believe attributed to the defendants during that time or at least their activities. Now, if there's more that's going to be brought out than in this report, then the people should turn that over. Mr. Khan says yes, and we will turn all that over this morning, Your Honor. The court says it's premature at this point for me to do anything other than rule that Mr. Anderson won't be permitted to testify about anything besides the camcorder incident until such time as discovery is turned over to the defense and they have an opportunity to evaluate it and I hear further from them. I don't want to hear why it is now this information I'd want to hear now why it is now that this information has been developed that didn't occur earlier. Any hearings or matters that we have to deal with in regard to the direct examination of this witness that's on the stand. Ms. Tari says, yes, Your Honor, very briefly. I'd ask that the witness be excused. The court says, okay, please wait out in the hall. The witness does so. Ms. Towery says, I don't know what the areas of redirect will be. However, Ms. Nahara did indicate to me yesterday that in redirect she does intend to inquire of Ms. Pisarcik about the night that she spent with Lyle Menendez before the memorial service in Princeton, and basically intends to elicit testimony from Ms. Pisarcik that Lyle Menendez attempted to manipulate her into having relations with him that evening. Um, okay. This is new information first disclosed to the defense yesterday. This is absolute bullshit. Sorry for the language. It is. You're now disclosing things for two witnesses the day of. This is a common problem that the state continues to have, and the judge is not doing anything about it. This is garbage. Anyways, who's talking? Ms. Towery continues. It's also a conclusion on the part of the witness. It's also inflammatory, irrelevant, and raises all kinds of ridiculous side issues regarding the intimate relationship between the witness and Lyle Menendez. I would ask that the court conclude that under 352 and also under the discovery violation, she's talked about that evening on numerous occasions and has never mentioned that particular conclusion on her part. The other issue that I imagine will come up is I believe that the prosecution may take the position that because Ms. Pisarcik volunteered in response to questions regarding Lyle Menendez's emotional condition but during the fall of 1989 in January, Ms. Pisarcik volunteered that he was emotionally spending money, and I expect that the prosecution will now take the position that the door has been opened to evidence of spending by Lyle Menendez, and that was precluded in her direct examination because of no discovery on that issue. And we still don't have any discovery on that issue. There still is nothing specific that has been provided to the defense, so I would ask that the court also preclude that area of cross examination or of examination. Otherwise, I haven't been advised as to anything that Ms. Nahara intends to go into. The court says, what is the people's response? Ms. Nahara says, as to the first issue regarding, I believe the defense tried to basically elicit testimony to provide a picture of Lyle Menendez the night before the memorial service in Princeton that he was emotional and broken up, and this would only be relevant to his state of mind and you know how this all affected him. And they try to present him as being somehow very emotional about this, and it was all part of this whole emotional defense that that I think they're going to try to develop, obviously, at a later time. This witness's recollection does not reflect the true state of events. True state of events that night is he did cry, he did lie to her, and he did, in her opinion, as was the best person to judge, she was there and she can describe he was not broken up and distraught about this. He actually wanted to have relations, and that is real. So you've never had like relations in a moment of grief or sadness? Like what? Like people grieve in different ways, and and she might have tried to comfort him in that way, and to use that against him in this is just sick. And that is real. This is not the picture of somebody who's distraught about his parents' death, and that was the picture the defense tried to paint. I think we're entitled to show any evidence that dispels that image, and that's what that evidence is pertinent and relevant to. As to the spending, Your Honor, I believe she was asked whether or not it came up with regards to her breakup with the defendant and why any and questions were asked about his emotionality, and I believe she testified that she did not appreciate, or the reason she broke up with him was because he was emotional and out of control, and she said part of that was reflected in his spending and his lifestyle, and there was an indirect response to questions that were asked of the defense that were not objected to as non-responsive, and that would open up the door to, well, what exactly was it he was doing? The court's like, but the court says, like what? Ms. Tari says, that was my question. Ms. Nahara says, like spending out of control. She observed his spending. The court says, like what? Ms. Nahara says, the bedroom furniture. This has all been disclosed to them. The bedroom furniture that was bought from a furniture store on La Brea, a sound system, and all the stuff bought for the Marina City condo. So he furnished a condo? that was empty, that he bought that was empty. He bought things to put inside his condo. Like, really? We're saying that this is some kind of emotional spending? Come on. I know they probably didn't want to live in that house anymore after everything that happened in that house, and their relatives, aunts and uncles, gave them money from a insurance policy that they put out. I think it was Marticano who had an insurance policy for him and or for them, and that's what they bought all this stuff with. It wasn't the estate's money that they were spending with. So this is garbage and totally irrelevant. But whatever. Miss Towery says there is no such furniture store on La Brea, and the witness has no recollection of specifically what was purchased. It was just sort of a general furniture at this non-existent store in La Brea. Also, excuse me, a large TV at a non-existent store on Westwood Boulevard. Ms. Abramson says, we have done a little investigating, Your Honor. The court says, regardless of the details of the investigation or the potential rebuttal, it just seems to me that the witness has given these answers. They haven't been impeached by the defense. I don't see there's any probative value. So he's going to let it all come in going into the details of it. In her opinion, he was spending too much, and that was her opinion. It's been unimpeached that he was that was her opinion. So, as to the basis on her opinion at this point, I think under Section 352, the probative value of it would be outweighed by its potential for undue consumption of time and confusion of issues here at this point. And as to the reference to the intimate activities that night, I don't find from what's been presented to me that the offer of proof here meets the purpose for which is being made. So he's not going to let it in. It doesn't support the position. It's not probative of the issues of the prosecution that the prosecution seeks, and therefore the court finds that under Section 352 of the Evidence Code, the probative value of that evidence is substantially outweighed by the potential for prejudice and undue. No, he is going to let everything in. So, any other issues that relate to the testimony of the witness? Ms. Abramson says, not that we know of. Ms. Nahara says, not that I'm aware of, Your Honor. The court says, okay, let's get the jury out and the witness in. So now the court says the jury is in court. Good morning, ladies and gentlemen. We're ready to resume with the trial. The witness is still on the stand. Would you state your name for the record? Jamie Pisarcik, the witness at the time of adjournment has resumed the stand. She's still under oath and redirect examination resumes. However, we are going to stop here because I know this is going to be like a much shorter stream today, unfortunately, but I'm trying to get through the Karen Reed case as well, and making sure that because this Friday is the May 9th is the hearing to recuse and disqualify Nathan Hochman, the DA. So I'm going to try to get us through the recusal motion and then Hochman's response to that this week as well. So I've got a lot of recording and a lot of trial watching to do. So just to try to fit as much as I can for this week, so I can stay timely, I'm going to give you a shorter episode. So I apologize for that, but fortunately, you'll be getting more content this week, so that's a good thing. All right, so thank you guys so much for watching. We will be back on Friday with Jamie Pisarcik, the final part of Jamie Pisarcik's testimony, and we're going to do her redirect examination and recross. So that'll be Friday, and then before Friday, I will have for you hopefully the recusal motion and also the Hochman's response to that. So stay tuned for that. Thank you guys so much for watching. Please hit the like button on your way out, and don't forget to subscribe, do all those YouTube things, and I will see you guys in the next one. Take care. Bye now.